Page 1, Ashley Sumner versus Anthony Voorhees.
For the record, this matter is before the court on the plaintiff mother's motion for custody, parenting time, and child support. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the plaintiff mother, Ashley Sumner. Ms. Sumner is present. In addition, Attorney Cassandra Suter is present representing defendant father, Anthony Voorhees, and Mr. Voorhees is present. Good morning, everyone.
Good morning, Your Honor.
The parties have met and conferred with Ms. Mayville from the front of the court this morning, who has provided the court with the following recommendation: that the parties shall share joint legal custody. The issue of physical custody is being reserved. And then this court's opinion, people get hung up on physical custody. We should be talking about joint legal and parenting time. With respect to parenting time, on a temporary basis, the defendant father shall have parenting time every Saturday from 10 a.m. until 3 p.m. at the Mile and Dragway, or is agreed upon by the parties commencing May 4th, 2024. And the parties shall appear back before this court for review on June 25, 2024 at 9:30 a.m. That is the recommendation. Ms. Nemec, is this recommendation agreed with your client this morning?
It is, Your Honor.
Is the Mile and Dragway still open?
I believe so. Ms. Sumner is going to be present for the parenting time. I believe that this is where the parties are meeting. They might not stay there for the entirety of the parenting time, but because of the distance between the parties, that's where they have been meeting the past few weekends. It just works out for both of them.
Not really, but sorry.
Yes. So will this be supervised parenting time? If they decide to go to a park, Ms. Sumner will accompany the child?
For right now, the parenting time would be with Ms. Sumner present. When we come back on June 25th, we're hoping that Mr. Voorhees, or I'm sorry, it's Voorhees, will have a living arrangement closer to Ms. Sumner at that point. Right now, he lives approximately 2.5 hours away, and the party's daughter is only 9 months old. So what we were trying to avoid was putting her in the car and making her drive long distances. Mr. Voorhees doesn't have any family in the Monroe County area, so he doesn't really have anywhere to go with River during that time. So the parties are just going to conduct this parenting time together until we come back on June 25th.
All right, thank you for the explanation. Ms. Suter, your client's position as this recommendation?
We are in agreement with the recommendation for the interim, and then June 25th, we're hoping for, I don't want to call it supervise in a way that he needs her there, but it just works out that they have more time together with River. So yes, we're fine with it right now. June 25th, we will be requesting overnights, and we will take care of child support and all the other matters that need to be taken care of.
Very well. Obviously, both parties did participate in the discussions with Ms. Mayville. Do counsel wish to voir dire your respective clients regarding this temporary arrangement?
I don't feel it's necessary. Thank you, Your Honor.
I also don't feel that is necessary, Your Honor. Thank you.
Very well. Very well. The court would like to thank Ms. Mayville for her assistance this morning. The court will adopt the recommendation. We'll see everyone back here then on June 25 at 9:30. Once again, via Zoom. All right, that will conclude this matter. You can all zoom out. Have a good rest of the day.
Okay,
Thank you, Your Honor.
Page 1,
Kirsten, can I talk to you for a second?
For the record, this matter is before the court on a number of issues. First of all, the defendant father's objection to a referee recommended order of child support. Defendant father's emergency motion for modification of parenting time, as well as the plaintiff's motion for order to show cause, alleging that the defendant has violated prior orders of this court. This hearing is being conducted via Zoom. Present is Attorney Leah Worker representing the plaintiff mother, Jennifer Jukri. Ms. Jukri is present. In addition, defendant father, Anthony Jukri is present. Good morning, everyone.
Good morning, Your Honor.
We have an issue
All right,
with audio. I'm sorry.
We'll first address Mr. Jukri's objection to a referee recommended order of child support. The recommendation was
I don't mean to interrupt,
$655.
Your Honor. I'm having an issue with my audio. I don't know if you can hear me. I'm trying to figure it out real quick. I apologize.
We can hear you, Mr. Jukri. Can you hear the court? Mr. Jukri, the court can hear you. Can you hear the court? You were fine, Mr. Jukri. Mr. Jukri, can you hear the
To
court?
go into my earpiece. Can you put a hand up if you can hear me?
We
Or
can
somebody-
hear you.
I don't.
We
Okay,
can hear
all
you.
right,
Can you hear the court, Mr. Jukri? Mr. Jukri, can you hear the court?
What's that?
Can you hear the court, Mr. Jukri?
I can barely hear. I'm trying to get it connected back to my headphone and it's not.
Put the device up to your ear then. We can hear you fine. Put the device up to your ear or turn up your volume. We can hear you fine.
Okay.
If you have problem, we give you a phone number. You can call in if you want to appear by audio. That might be better.
Yeah, I will call in if that's okay. I'll call in right now. I have
Okay.
the.
Do you have a piece of paper and a pen?
Session, middle page 2, Nolan Fox versus Kathleen Sanger.
For the record, this matter is before the court on the objections filed by defendant Kathleen Sanger to referee recommend order adjourning without date her motion for child support. And this hearing is being conducted via Zoom. It appears we have both parties present, Nolan Fox and Kathleen Sanger. Good morning, both of you.
Good morning.
Your Honor.
The two of you have conferred with Ms. Mayville from front of the court this morning. Ms. Mayville has provided the court with a fine recommendation. The recommendation is that referee recommend order be rescinded and canceled. As Ms. Sanger, you are withdrawing your motion to modify support or for child support. Is that correct?
Yes, we've agreed to revisit it when necessary.
Okay, so you can just simply refile that motion when you deem it's necessary.
Okay.
So you're agreeable with this recommendation then this morning, is that correct?
Yes.
Fox, likewise, you're agreeable with this recommendation?
Yes, Your Honor.
And well, it's wonderful. Obviously, things are working well because the court hasn't heard from from either of you in a while. So I trust things are going well with parenting time.
Very grateful for Carrie Curris. She's been a godsend. So I just say that's why we're removing the order for right now, because Carrie is helping out extra. So I just appreciate her. And if we could have her name be put out there just to be, she helps out a lot. So when she's helping them out, there's no reason for me to come after Mr. Fox.
Wonderful, wonderful. Court, please hear that. Okay, very good. That's beneficial for everyone, including your child. All right, the court will adopt the recommendation. The copies will be mailed to both of you. You can both zoom out. Have a good rest of the day. Thank you, Ms. Mayville.
Thank you.
Thank you, Your Honor.
You're welcome.
Yes, sir.
So you've decided to appear again by video. All right, we can recall the case.
Court is recalling on page 1, Jennifer Jukri versus Anthony Jukri.
All right, for the record, once again, this matter is before the court in numerous matters. First of all, the defendant father's objection to a referee recommended order of child support, defendant's emergency motion for modification of parenting time, as well as the plaintiff's motion for order to show cause, alleging that the defendant father has violated conditions of this order, of prior orders of this court. Again, all three the parties are present, along with Attorney Lee Rourke, representing the plaintiff. And this hearing is being conducted via Zoom. The parties have conferred at length with Mr. Pratt in front of the court this morning. The court will first of all address Mr. Jukri's objection to a referee recommended order of child support. That recommended order was $655 per month. And Mr. Jukri, the court determines that your objection is untimely. You had to file that within 21 days of it being mailed. It's untimely. So that referee recommended order will be adopted. Do you understand that?
Can I respond to that?
Well, I mean,
Your Honor.
it's either timely
So
or it's not.
at the time I still am currently homeless, living in my truck. I was working at Grand Gulf Nuclear Station in Gulfport, Mississippi. I was working 712s. I reached out to the courthouse at least 30 times trying to figure out how to file a response to that. With working 712s and doing that, I didn't, and I couldn't figure out how to do it. So finally, a representative from the courthouse on the 20th day did tell me how to do it and that I could do it remotely, because I was being told I had to do it in person. So I was able to fill everything out and have it submitted on the 21st day, and the hearing was also scheduled on the 21st day. I also understand I don't have an attorney. I'm doing the best I can, Your Honor.
Yep, I appreciate that. So the court's going to adopt the referee recommended order at this point in time. The court's denying your objections, Mr. Jukri. your option at this point in time, you can file a motion to reduce support. If you claim you have reduced income, you can't pay this it's pretty, not a whole lot, $655 for one and a 14-year-old child. So your only alternative at this time is to file a motion to modify, reduce that, and show you have got reduced income. So that's going to address the issue of child support at this point in time.
I do have one more issue with that, Your Honor. So I told Jennifer, my main issue with child support is not paying it. I'm back to work now. I can pay it. That's fine. My main issue I had with it, Your Honor, is that, and I have the app closed messages here, on 11/30 of 2023, I informed Jennifer that I was homeless. And as you know from recently, my car was totaled at a job. So I didn't have a car. I was homeless. And Jennifer responded, well, I'm sorry. I don't know what I can do to help. And then the next day went to her an attorney and filed for child support. Now, I know it's her right to get it, but for 6 months of the process of our divorce, she never wanted it, never asked for it. And I believe it was malicious intent. I tell you one day I'm homeless and don't have a car, and the next day you go file for child support, and now I'm buried in debt. So all I ask is that since child support started coming out 3 weeks ago, that the rearage be dropped, and I will continue to pay child support.
Your concern is noted, Mr. Jukri, but the court is adopting the recommendation. And that, of course, the effective date is of December 1st, 2023. It's your obligation to keep the front of the court informed of any change of address. So the fact that you didn't get I'm not sure if you're claiming you didn't get the order timely, that's on you. So the court has adopted the front of the court recommendation effective December 1st. It can't be a significant, huge arrearage. Mr. Jukri is going to
over $2,000.
All right. Well, again, obviously, you want to just slowly chip away at that. You don't need to pay in one lump sum, but slowly chip away at that. So that issue has been addressed.
Well, my issue is to show Jennifer's malicious intent, which I will continue on with this hearing today with other instances. So I ask that you just keep that in mind.
Right. It's noted for the record, Mr. Jukri. Okay. The other issues. You filed the emergency motion for modification of parenting time. Of course, I know you've subpoenaed witnesses. They're apparently in the waiting room. And apparently, you are alleging that Ms. Jukri consumed alcohol at the Monroe Street Grill. Is that correct? And that's your basis for modified parenting time?
The situation of what happened at Michigan Bar and Grill, which she admits to, my 14-year-old daughter called me that night. And I was working at Fermi Nuclear Power Plant in Monroe, just to show you further that I am sober and I am going to work. I'm working at nuclear power plants. Okay, so while she's denying me time to see my child, and I was trying to work.
Hold on, Mr. Jukri. Mr. Jukri.
Yeah,
we're going to stop you right there.
Okay.
Again, the court has ordered you twice, October 17th, 2023, February 6th, 2024, to submit to a 7-panel hair follicle to address parenting time. You've never done that, so there's nothing to talk about parenting time until you do that, Mr. Jukri.
Can I elaborate on that? I'm not wasting the time. That's not 100% accurate.
So
the first hair follicle you got rid of. No, Your Honor, the first hair follicle you got rid of because I was homeless, and you told me if I submit to a urinalysis and a second full drug assessment. So if you go to page number 9 on that emergency custody hearing, there is my urinalysis, there is my full drug assessment, evaluation, and questions. And I've done this twice, and I've also submitted in here, and I need you to keep in mind, I've been homeless since November. I've been living out of my truck for months, traveling around the country, different nuke plants, different coal burners, trying to get ahead, which is why you did put an order in for me to get a hair follicle. You ordered Jennifer to pay for it. I reached out to, and even though we were in court and I said, no, I don't want to do it, because I knew Jennifer would not pay for it. So after that, even though I contested it in court, I emailed Mrs. Verka 5 times telling you I'm in Sarasota, Florida, pick any lab and I will go submit to this hair follicle. And I sent those messages from the 2nd day that we had court up until the 7th day. And they never paid for the hair follicle. I was living in my truck.
Mr. Jukri,
I could not pay $380 to $500 per, yes.
Mr. Jukri, it's not their obligation to find a lab for you. You identified the lab, and then you then inform Ms. Luberka, and Ms. Jukri will pay for that. It's not their obligation to locate a lab, and then you'll say that's not convenient. You determine the lab. So we're not going to talk about parenting time because you've not complied with orders of this court.
That is not what the court order said. It just said the court order, and I want you to keep in your mind, I don't have an attorney. I don't have access to transcripts as I'm on the other side of the country. The court order states Jennifer is ordered to pay for hair follicle test within 7 days. To the best of my knowledge, without an attorney, without guidance from the court, which I have none, I reached out to Mrs. Verka, and in spite of not wanting to pay for it, I said, I am in Sarasota, Florida. I'm here working. You know, I'm living in my truck. My phone's dead half of the time. I don't have the resources to go around and call and try to find a lab. And not only
You're
that,
living there, Mr.
by
Duke,
doing
you're
that
living
for
there.
them,
You're living
I
there.
was working,
It's
Your
a lot
Honor.
easier when you're living there to find a lab rather than Mr.
I
Duke to
was
find a lab from
working.
Michigan.
I was working 12 hours a day, welding outside in the heat, going to truck stops to take showers and baths, and sleeping in Walmart parking lots. I did the best that I could, and I'm pretty sure like those 5 emails show my willingness that I will submit. So people that are sitting at home and do have a job and do have computers and have all this access could have in 2 minutes pulled up Sarasota, Florida lab. Here you go. Because further, I did call and I find out they cost $380 to $500, which is why I'm sure she didn't want to pay for it. But also that she can pick a lab and she can find out which one is cheaper and save herself money. I did the best I could to follow, and I emailed them at least 5 times.
It's your obligation to locate a lab, Mr. I'm not going to keep repeating myself, Mr. Jukri. It's your obligation to locate a lab. You identify the lab, you inform Ms. Werka, and Ms. Werka will see that that is paid. Otherwise, we're not going to keep.
That's not what the court order says.
Things have already been addressed.
That is not what the court order says that I had access to. That is all I had access to. The court order that I have access to says Jennifer is to pay for that. It doesn't say Jennifer has to pick a lab or Anthony has to pick a lab. The court order, the only thing I had access to without an attorney, says Jennifer is to pay for hair follicle tests within 7 days of this court date.
Right, Mr. Jukri, if she picks a lab, you're going to say, well, that's not convenient. Not convenient. It's too far that they don't have the hours are limited. So no,
I said I was in Sarasota, Florida, and you could pick any lab in Sarasota.
Mr. Jukri,
I identified a whole county. I identified a whole county for them, Your Honor. A whole entire
county right now. Mr. Jukri,
I'm not in Monroe County. I'm in
correct?
No, I am in Southern Ohio. I am in Middletown, Ohio, working 7-12.
So find a lab that does hair follicle tests in that county. You inform Ms. Werka of the name and phone number that lab, and then she will facilitate payment of that. Don't worry about the cost.
If I may have just an opportunity to respond.
No, the court's not going to. This is not a trial. We're not going to take all day on this.
Your Honor, I understand
Mr.
that.
is not complying with orders of this court. I understand it's his obligation to identify a lab. Then you can pay that, Mr. Orca.
Okay. I will get it taken care of this week, and I will pay for it.
My client is no longer willing to pay for the hair follicle test. He's had an additional 3 months.
It's already been ordered, Ms. Orca. We're not going to go back. It's already been ordered. So once he identifies the lab, she should pay for it.
He was ordered to do it within 7 days. That's now 3 months later. He didn't do it.
Understand? He's died a number of times, but I still want that hair follicle test. That's ordered the court. I'm not going to go back on orders of this court.
I understand, Your Honor.
Mr. Jukri identifies the lab. Ms. Jukri will pay that. We're not going to go back and redo orders because the parties are not complying with it. So the parties have conferred with Ms. LaPrade. Ms. LaPrade has spent a lot of time with the parties this morning. Her recommendation is as follows: that upon father completing the hair follicle test, as previously ordered, the father shall have parenting time 6 weeks during the summer with the notice prior to June 1st. In addition, the father shall have 1 week for Christmas, 1 week for spring break, and they shall have reasonable liberal time, parenting time with 7 days advance notice to mom while here in Michigan. It's further noted that there's been no hair follicle test as of this date. She's recommended that the parenting time complaints filed by Mr. Jukri be denied, as there's no violation. Because parenting time was to begin following the hair follicle test. There's not been any. It's further noted that father has violated the order multiple times regarding this case and making disparaging remarks. Mr. Jukri had no right to go to your daughter's school, take her out of school to the office to visit with her. You do not have any visitation with her until you complete the hair follicle test. So that's the reality of the matter.
Okay.
The court is not convinced there should be any basis to modify parenting time, so the court can deny that request, and that will conclude this hearing.
Okay. Can I go to the emergency custody hearing and why did I file this emergency custody hearing? Which is not, it's actually a motion regarding parenting time, but again, I'm not an attorney and I've done my best So if it's okay with you, I would like to read the statement that I wrote that Jennifer admitted to.
Go ahead, Mr. Duke. I have the cases
So
this morning.
I understand. So Jennifer admitted to trying to take my daughter to a bar, to Monroe Bar and Grill, which is two separate entities. There's a bar entity and there's a restaurant part. Jennifer's intent was to go to that bar to drink and do karaoke. My daughter did not want to go. I was in town, Michigan, working in Monroe. She denied me to see my daughter. I was trying to reach out with Catherine Scott to at least get supervised visits. So keep in mind, while she's telling the courts that I am not sober and can't have my daughter, she admitted to leaving my daughter at home on a school night, a Tuesday night, that did not want to go to the bar with her mother. So then she went to the bar, started drinking. Two people that I know saw her, and my daughter had already called me. And Jennifer admitted to getting in her car after drinking and driving back to her home. And then going back to that home, she's under the influence of alcohol, taking care of my daughter. And we all know what just happened to the Swan Creek Boat Club. So she's admitting to doing the same things that just happened.
With her mother? Was your daughter in the car with her mother after the mother left?
She was not, but she tried to take her with her. And this is the only thing that I can prove that she admitted to. There's been many other instances like this. I just don't have the proof, and she finally just got caught. And she admitted to it. So then she's going home under the influence, taking care of my daughter when she's accusing me of not being sober. When the fact is, she hasn't seen me in 106, almost a year. She has not seen my face. She has no idea what I do. And to further go, you took away my parental rights in June, Your Honor, because Jennifer lied under oath.
Court has not taken away your parental rights, Mr. Jukri.
Okay, my parental time. I haven't seen my daughter in 10 months. And
apply with
for the second time,
get the hair follicle test is brief the order. I've told you
I want to show that Jen has committed perjury in your courtroom twice. So under oath, she said that I was in the hospital for meth. You have the records in front of you that show that I was not on meth. I had sepsis from a burn, and that is true. And that's why my parental rights were suspended. And I've been fighting this for months. And most of the time being homeless. And I'm not finished yet, Ms. Verka. So then there's I'm not finished yet, Mrs. Verka. You'll have your time to talk.
All right, so the court's adopted recommendation. The court has heard enough this morning. You're going in circles, Mr. Jukri.
No, there's not. There's more perjury, Your Honor. Your Honor, there's more perjury that you need to hear.
You mute him, please. We're going to mute Mr. Jukri. The court, there's no evidence that she has neglected your daughter. She's a 14-year-old. She's not a 6-month-old. That mother had a couple of drinks and would come back and try to address a 6-month-old child. It's a 14-year-old daughter. There's no evidence or allegation sufficient to cause this court to have a hearing that the child's been neglected. So the court's going to adopt this recommendation of Ms. Pratt. Now we'll conclude this matter. You can all zoom out.
Your Honor, just briefly, we did request attorney's fees yet again. It's been previously reserved on our prior show cause petitions that we filed for the same issue with Mr. Jukri continuing to discuss this case and disparage my client to the minor child and continuing to harass and abuse her via app close.
Right. All right. The court will reserve your request for attorney fees, Mr. Worka. That will conclude this matter. All right, Mr. Jukri, get the hair follicle test and come back before this court, please. So you can zoom out. Copy the order we mailed. For the record, this matter is before the court on the plaintiff's mother's motion to modify legal custody and to appoint plaintiff mother as a medical decision maker relative to the minor child. This hearing is being conducted via Zoom. President's attorney Margaret Beck representing the plaintiff mother, Nicolette Hughes. Ms. Hughes appears to be present with Ms. Beck. In addition, attorney Michael Spiros is present representing defendant father Andrew Ozak. Mr. Ozak appears to be present with Mr. Spiros. Good afternoon, everyone.
Good afternoon, Your Honor.
The parties have met with Ms. Brower for the front of the court this afternoon. Ms. Brower has recommended that the court that the plaintiff's motion to modify legal custody and appoint plaintiff medical decision maker be denied. That is a recommendation. Ms. Beck.
Yes, Your Honor. Obviously, we disagree with that recommendation. We do believe that proper cause exists to appoint mother as the medical decision maker for the child. This particular instance relates to child's behaviors while in mother's home, which are of grave concern. in particular, defiance, temper tantrums, violent behaviors, in the form of, I think she carved her initials or her name into a door in mother's residence. She also throws things, and is verbally attacking the younger children who are in the home. Mother has attempted to resolve this with father, but these attempts go nowhere. This is similar to the circumstance in 2019, when mother wanted to put the child in counseling and father said no. The parties had to return to friend of the court to get an order to that effect. And whenever there's a disagreement regarding medical decisions, father wins because by saying no and digging in, he simply doesn't have to agree, and the child doesn't get the care that she needs. Mother got a referral to a psychiatrist from the child's pediatrician. She did contact the pediatrician to make an appointment for one of the younger children. Described the behaviors on the phone to the pediatrician, and the pediatrician gave the referral for the appointment, or for the psychiatrist, Your Honor. We do have, the parties communicate by app Close, which is an app similar to Our Family Wizard that the parties use. And if you allow me to share my screen, Your Honor, I have the exact exchange available, as well as a copy of the referral if you'd like to see that.
I think you attached to your pleading, did you not?
I don't remember. I might have. It's not attached to my copy, but that doesn't mean it's not attached to yours.
There was I believe a text message that was attached, and
oh, perfect.
The court's opinion is that response was perhaps could have been more appropriate. Certainly was not constructive decision on the part of dad when he says, "Oh, mama must be either one needs psychiatrist." Clearly, that's inappropriate response for dad. Not constructive at all as a parent. So yes, I've seen that exchange.
Okay, thank you, Your Honor. And so that's really the issue. It's dad pushes this back on mom, says, "No, mom, it's the child's fine," and the child does behave well everywhere else. But something's gone askew in mother's home, and we're not competent or able to determine what that is. The counselor isn't helping, and the pediatrician felt enough to make a referral to someone else who could potentially make that decision. We believe that father's failure to participate in the care is what is impeding mother from getting medical care for the child and is not in the child's best interest. Again, this happened in 2019. Mother had to return to court to get the child in with a counselor to begin with. And, the child is 10 years old, Your Honor. We're going to have problems moving forward of a non-emergency medical nature that are going to require someone to make a decision. When dad behaves this way and says no every time, or simply that it's mother's problem, it's just not in the child's best interest. And that's why we're asking for just this narrow issue in the custody arrangement to be modified, to allow mother to be, for lack of a better word, the non-emergency medical decision maker.
Thank you, Ms. Beck. Mr. Sparrows.
Your Honor, the pediatrician who made the referral never saw the child. And interestingly, the counselor to whom the child was eventually referred does not recommend that the child see a psychiatrist, and to express it in terms of father disagrees every time. It's been twice, and there is no valid reason for this child who exhibits no behavioral problems anywhere else except at mother's home to be referred to a psychiatrist, and the stigma that goes along with that. So we're asking that the petition be denied, and we don't believe that on its face, the petition states sufficient grounds to grant the change or modification, as they put it, in custody without the requisite good cause or material change in circumstance.
Thank you, Mr. Sparrows. So Ms. Beck, obviously it's alleged that the child has been exhibited defiant conduct at mother's home. What about any evidence of issues at school? Have the teachers at parent-teacher conferences brought to your client's attention the child's acting up in school?
No.
What about any opinion from Kelly Crampton, the child's counselor? Have you saw an opinion from her, who apparently sees Ellie on a regular basis? She suggested there's some concerns.
Your Honor, the child is well behaved at school. There are no issues there. And she does see the counselor. It's my understanding with the counselor, she was asked about this. The counselor's response was she didn't know if Ella would qualify for psychiatric services and referred mother to Harbor Behavioral. for further assessment. And it's my understanding that this particular counselor doesn't force the issues with Ella, but it's more of a, if Ella decides she's going to participate, she's allowed to participate. So no, I don't really, we didn't seek a referral from the counselor. It was from the pediatrician.
At this point in time, Ms. Beck and Ms. Hughes, the court does not believe there's a significant change of circumstances to warrant a modification of legal custody. So at this point in time, the court's going to deny without prejudice the mother's motion to modify legal custody and appoint her as a sole medical decision maker. Ms. Beck, if in fact you receive a letter from someone at school, there's issues, she's acting out of school, a letter from Kelly Crampton saying that they have concerns that she needs to see a psychologist. So the court would entertain if you want to, so just not without prejudice. If in fact there's something more than what's exhibited in mom's home, the court would look at it again. But at this point in time, if in fact since father denies the request and will not agree to the child see a psychiatrist, the court is not going to require that without something more.
All right, Your Honor, thank you.
This time, you're welcome. The court will deny without prejudice your motion to modify custody and appoint mom as sole medical decision maker.
Thank you, Your Honor.
All right, that will conclude this matter. And Mr. Ozak, when there's a concern stated, I mean, don't just throw it back in mom's face. Be constructive and ask, okay, what's happened? I mean, there should be, come on, you're the parent, and you should be more concerned about the welfare of your daughter and make more of an inquiry, a good faith inquiry rather than just throwing it back in her face. So with that, we can zoom out. Have a good rest of the day.
Thank you, Judge.
Welcome. For the record, this matter is before the court for continued pre-trial conference subsequent to mediation. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, representative of the plaintiff Heather Straub, and Ms. Straub is present, and defendant Charles Straub is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
Court has been informed by Mr. Walker that Mr. Straub does not wish to mediate this afternoon.
My understanding.
All right, Mr. Straub, you should have told me that. We're wasting everyone's time. If you said, no, Judge, I want a trial date, I don't want to mediate, nothing to discuss. Could have avoided wasting Ms. Hill's time, Mr. Walker's time. All right, so as the court recalls, and I will assure you, Mr. Straub, the best resolution is one which you participate. You go to trial, the courts can make the decisions, and normally most people want to have some input in those decisions. And in the court's recollection, there's only three main issues: child support, spousal support, and defendant's interest in a marital home. Whatever the interest is to be, was reduced by $5,436. Those are only four issues, as the court recalls. Is that correct, Ms. Hills?
So those are the main issues. There are a couple of miscellaneous issues. In the meantime, we have filed a show cause relating to Mr. Straub's removal of some personal property from the marital home in violation of the exclusive use order, and appearing at the marital home in violation of that order. We also, he had scheduled a hearing that he failed to appear for, asking to vacate the previous agreement. And the court ordered $520 of attorney fees to be paid by today. Granted, he has until the end of business today, but I'm not optimistic that that payment is going to be made in a timely manner. Mr. Straub also owes me interrogatory answers. Those are well overdue at this point, and I would certainly need those prior to any trial date.
Right. All right. So, Mr. Straub, there's some preliminary matters that need to be addressed before we can schedule a trial date. The interrogatories, when can those be returned to Ms. Hills? Overdue.
As soon as I can get to them, I apologize. I've had a lot I've been trying to do. And as for the not telling you about the date, I just made the decision just now when I was talking to her when all of this went down earlier today. I would have told you earlier, but I had just made a decision that this is the route I wanted to take. For the record, I wasn't doing it for like out of disrespect or to anyone. It was because of the information between me and Ms. Hills wasn't getting sent properly in a way to where I felt like I could. I don't even want to participate, honestly. So, I do feel like you could do a better job than at the point of where that I met with it. So, I feel like it's helping and not wasting people's time by just having the trial just go ahead. And I'll
I'm
get
sorry.
to those things as
Mr.
possible.
Straub, your language is not real clear. I'm having a hard time deciphering your language. Perhaps I give you a phone number, you can call in, it'll be much clearer. It's not, your language is not picking up. I don't know, Ms. Hills, did you follow everything Mr. Straub just said?
It was difficult, but I think I followed what he said.
Okay, the court could not. Mr. Straub, if you got a piece of paper and a pen, I'm gonna give you a phone number, you can call in, appear by audio.
Can you hear me better now?
That's a lot better. Yes, a lot better.
Okay, I had a special case because I'm a maintenance guy to get my phone protected. I apologize for that.
Okay, that's much better.
Yes.
Okay, so do you want to
what I
repeat what you
stated
previously
was,
stated?
yes, sir, is I didn't know that I was gonna want the trial until just now, earlier today. I kind of just now made that decision because me and Miss Hills, when I get information, when I share it between me and her, the information that she gives to me is fake. And I have the proof of this to show you, and she's done it multiple times. So it confuses me. And then I can't make rational decisions based off of the information that me and her are sharing. So because of this, I just want to go to trial so that I can show you what has actually transpired to this point. And then, and I don't feel like I'm even really involved in it anyway because everything gets twisted. So I prefer you just to actually you do it. And then I know I might not get but I'm a fair guy, and I think that it'll be fair. So I'm not really worried about it, actually.
Okay. Okay, before we set a trial date, Mr. Straub, Ms. Hills is entitled to your written answers to those interrogatories. So the court's question is, can you have those to her by the end of this week?
Yes, sir.
Okay, well, today's Wednesday. Do you need till the next week to do that? We're not going to play games here. I want a definitive date, but you need to sign.
So if I can have a full week,
hold on. You need to sign. You need to complete the answers. You need to sign them before a notary, and then return them to Ms. Hills.
Okay.
Can you do that? What, a week from Friday, say May 10th?
Yep.
All right. How many interrogatories are there, Ms. Hills?
120 with approximately 20 with subparts.
Okay, 21. And can you do that by May 10th? That's a week from Friday, Mr. Straub?
Yes, sir.
All right, so ordered. Finally, there's a show cause before the court this afternoon which needs to be addressed. First of all, you filed a motion which was to vacate a divorce decree, and you didn't show up on your motion hearing. You scheduled for a hearing. You did not show up on April 3rd, and the court awarded Ms. Hills $520 in attorney fees. You need to pay that to her today. So it's 2:30. You got till 5 o'clock to pay that $520 to Ms. Hills. Mr. Straub?
Okay.
Can you have that paid to her today?
Yes.
Okay. Finally, it's alleged you violated a prior restraint of his court, prior orders of his court, that you entered the home, or you went on the marital property and you took a boat and a trailer, contrary to this court's order that you not do so. What's your response to that?
Mr. Straub told me I could take the boat.
Where is the boat?
In my front yard. I have I have 90% of my awarded items. Ms. Straub has slowly given them to me, just not all of them. And the boat was one of them. And she told me I could take the boat.
Your Honor, I can clarify that. She did initially tell him on the 20th of March that he could take the boat. That was before she let me know that he had asked to do that. He had filed the motion to vacate the settlement agreement at that point. She then revoked her consent for him to come and get the boat until that motion could be dealt with by the court. He then failed to show for his hearing. The court denied the motion, and at that point, I did advise my client that she could start turning over that property to him. But on the 29th of March, he had no permission to be on the property whatsoever, or to take any property. The court had not heard that motion at that point.
All right, but was that the boat and motor ultimately awarded to Mr. Straub as part of the settlement agreement previously placed on the record?
It was.
All right. All right, so obviously there's some confusion there, some misunderstandings. So I believe the court's opinion that deals with that issue. Mr. Straub's in case he can pay $520 to Ms. Hills today. He's going to respond to the interrogatories by May 10th. Ms. Hills, anything else that needs to be addressed before we schedule a trial date?
Yes, Your Honor. We had at the last hearing, as part of the agreement pending today, left Mr. Straub as an authorized user on my client's Cabela's credit card. He has since, and part of the agreement was that he would be responsible for any charges after the date that that partial settlement was put on record, and that she could make adjustments to the amount of equity owed to him if he failed to pay those charges to her. Since then, he has basically been running up the credit card, buying new large items of personal property, using the credit card far in excess of the status quo. The amount of equity that we believe will be owed to Mr. Straub, given Mr. Evans' historic and current appraisals of the property, with an adjustment for Mr. Straub's share of the marital debt, which had also been agreed to at $5,000 and change, she would owe him about $7,500. He has already charged up over $2,000 on that card. We're very concerned that he's going to keep going now pending trial. So she is asking that the court at this point in time, given Mr. Straub's failure to mediate in good faith today, which my client came here to do, we were hoping strongly for a resolution today. We are asking that she be permitted to remove him as an authorized user of that account, or at least that a cap be put on the monthly amount that he can spend and base that on the status quo. I think we'd probably need to talk to Mr. Walker about that a little bit, but our first request is that he be removed as an authorized user from that account, so she does not need to worry about that amount exceeding the amount of equity that she will likely owe him.
And that's Cabela's account, is that correct?
Yes, it is.
All right, Mr. Straub, your response?
My response is, first of all, how would I pay Ms. Hills if she shuts off the card? So she's setting me up right there. It's very obvious. In order for me to pay Ms. Hills today, I definitely need the card that I think I am going to use to do that. You know what I mean? So that would be my first worry there. And my second worry is there's no proof that I ran it up with excess. Where's the proof? I haven't run anything up. And also proves that I'm only going to be awarded $7,000 for a house that's $190,000, more like $75,000, not $7,500, $7,000. So I'm should be enough for it to cover it, and or I'm not poor. So I could cover it or borrow it from my father, but shutting that card out today would absolutely make it to where Miss Hits would 100%.
I'm not sure what the Cabela's account has to do with your livelihood, but the court's going to order that Miss Straub can remove you as an authorized user of that Cabela's card. So you prohibit you from charging more than that Cabela's card, Mr. Straub. Okay.
So I can't use it, or?
That's correct.
Okay.
It's not critical until we have a trial date. You can get a Cabela's card in your own name, but you're getting removed as an authorized user of this joint Cabela's card. Let's not complicate things.
Okay.
Ms. Hills, you still need to talk with Mr. Walker to reckon something else?
No, Your Honor, I'm satisfied with the court's decision. Thank you.
All right. Ms. Hills, from your standpoint, how long do you need for a trial? Can we do it in half a day?
I think we can do it in a half a day. Yes.
All right. How many witnesses do you expect?
My client and Mr. Evans would likely be the only two witnesses.
Okay. Mr. Straub, how many witnesses would you call at trial? Again, there's only 4 issues at trial: child support, spousal support, as well as the value of the marital home and your interest in that home.
Probably 5 people.
Okay. Yeah, okay. You'll need to disclose the name and the address of those witnesses to Ms. Hills. We're going to establish a date which you must exchange the witness and exhibit lists. Ms. Hills, have you received a written appraisal from Mr. Evans?
Yes, Your Honor, we have 4 total appraisals, 2 historic, one from Mr. Straub's appraiser, one from Mr. Evans, and current appraisals from each as well. We have exchanged those.
Oh, so Mr.
Nope.
Straub has a copy of the appraisals in your possession, is that correct?
No,
My
I do
paralegal
not.
has sent those, yes. And we will
She did not
resend.
send me it. Yeah, because you didn't send it before and you keep lying. I'm sick of it. You didn't send it. You play
Okay.
games,
Yeah,
and I have proof of it, and I'll send it to the court if they'd like to see it. She sent me fake ones, hence why she has to resend them. You did not send me a current appraisal. I sent you mine. You did not send me yours. Not very fair.
All right, the court's going to order that both the exchange exhibits and witnesses by a certain date. We'll address just a minute. Mr. Straub, you're going to represent yourself with this trial, is that correct?
No, I'm trying my hardest to get a new lawyer. I called someone and they ghosted me, but I'm trying my hardest to get a lawyer for this. And if I do, I would request Ms. Straub to pay for that because she has the money to. And I don't. And I need to do a lot of discovery because they're not sharing the information properly, which I can show all of the information.
Mr.
when it's
Straub?
come in.
Mr. Straub,
sir.
we have that attorney on board within the next 2 weeks?
Yes, I will.
Right. Ms. Hills, I know we need to move this matter forward, but the court's reluctant to schedule a trial date. In fact, if we have an attorney on board that says I can't do it on that date, what's your thoughts in that regard? Do we set a trial date today, or do we set another pretrial in 2 weeks to see whether Mr. Straub comes back with an attorney?
I don't have an issue with the credit card issue being decided with coming back in a couple of weeks so that we don't wind up rescheduling a trial. I agree that would be a concern. I would also, if there is an attorney, like to have input from counsel regarding scheduling order information as well, deadlines as well. So I don't have a problem with a couple of weeks. However, if there's not an attorney on board in a couple of weeks, then I would certainly be asking the court to set a trial date at that time.
Absolutely. All right, so Mr. Straub, what the court's going to do today, we're going to adjourn for a couple of weeks so that hopefully come back with an attorney so that we can coordinate a trial date with that attorney's schedule to give you the benefit of having that attorney. And the attorney can perhaps work through Eli's issues with Ms. Hills. Maybe he can help you facilitate a full agreement, which would be in your best interests. But in any event, the only order of the court today is that you respond and return the answers to the interrogatories by May 10th, and you pay $520 today. Of course, also authorizing Mr. Straub to remove you as an authorized user of the Bell's account. So we'll give you some proposed dates for another pretrial. How about May 17th, 11 o'clock? Would you be available, Ms. Hills?
I'm checking right now, Judge.
Mr. Straub, it's a Friday, 2 weeks from Friday.
And this would be in regards to,
Just a pretrial. And again, hopefully you have an attorney here. If so, what I anticipate at that time, unless the attorney agrees he wants to meet with Ms. Hills, try to resolve this, the court would most likely schedule a trial date at that time. So if you don't have an attorney, the court's going to schedule a trial date on May 17th when you come back. If you have an attorney, hopefully to review that attorney's schedule to make it an agreeable date and time for everyone, any trial date. And that your attorney may very well, I think any good attorney is going to say, I want to talk with and try to review things with Ms. Hills and attempt to reach our own agreement.
I can do
So
the
the big question is, do you think you can have an attorney on board by May 17th? Give you 2 weeks from Friday.
yes, I am trying my hardest. I tried before and I already called someone and they kind of just ghosted me. But I will continue to try and I will try my best.
Okay. And you want to have that attorney appear then on May 17th at 11 a.m. That work with your schedule, Ms. Hills?
It does, Your Honor. It works well. Thank you.
All right. It'll be a Zoom pretrial conference. Mr. Straub will mail out your notice. You're still at 5.
Yes, sir.
They will mail you notice to appear via Zoom for a pretrial, May 17th, 11 a.m. That'll be a final pretrial. Hopefully you have an attorney on board at that time. And we'll go from there, but please make sure you pay that $520 to Ms. Hills by the end of today and answer those answers interrogatories by the 21st. I'm sorry,
Okay,
by
thank
May
you.
10th. I'm
By the
sorry,
10th.
a week from Friday. Okay.
Yep.
Thank you, Your Honor. I'll prepare an order.
All right. That will conclude this matter. You can all zoom out. For the record, this matter is before the court on the respondent, Russell Hennigan Jr.'s motion to terminate a personal protection order entered by this court on March 7th, 2024. This hearing is being conducted via Zoom. However, Russell Hennigan Jr., the respondent, is present personally. Per his request, he was having difficulty with technology, and the court granted his request to appear in person this afternoon. And ma'am, you are Tamaris Hennigan, is that correct?
Yes, Your Honor, it's Tamaris Hennigan.
Yeah, good afternoon, Ms. Hennigan. Ms. Hennigan is appearing via Zoom. Is there any merit in the two of you talking off the record if the court left the courtroom to try to work out your differences? We have a mother and a father here. The court certainly does like to see family conflict. And obviously, sometimes you have a hearing, it just widens that conflict. And the two of you, if we just everyone left and the two of you talked off the record, would that assist in resolving this?
No, Your Honor, unfortunately not.
Okay. All right, Ms. Hennigan, Mr. Hennigan, can you both please raise your right hand to be sworn, please?
Yes, Your Honor. Could I notify you there's several witnesses that zoomed in though, so I wanted to let you know so no one would be left in the courtroom on Zoom without you
Okay,
on.
well, we'll get to them. We need to, but this is not we're going to have maybe 20 minutes for this. I don't have a couple of hours for this hearing. It's a PPO violation. A PPO hearing should be quick. Well, do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. All right, Ms. Hennigan, you're still the PPO, so it is your burden. If you could please state your name and for the record, please.
My name's Tamaris Hennigan.
And you are the daughter of the respondent, Russell Hennigan Jr., is that correct?
I'm his biological daughter. I'm no longer legally his daughter.
Okay, that's not the question. You're his daughter, correct?
Yeah.
And at your request, this court did enter an ex parte personal protection order on March 7th, 2024. Is that correct?
Yes, Your Honor.
Okay. And again, I've gone through your fact statement. What stands out in the court's mind is this alleged incident of February 27th, 2024. Can you describe your contact with Russell Hennigan Jr. on February 27th, 2024, which you allege occurred at a funeral dinner in Adrian, Michigan?
Yes, Your Honor. I'm sorry, were you asking me to describe it again?
Yes, I mean, again, there's a lot of allegations of this and that, and Mr. Hennigan responded, he's helped pay for your education, a lot of things. Those things are all irrelevant. What the court's focusing on one particular incident, recent, you allege on February 27, 2024, you had an altercation with Russell Hennigan Jr. at a funeral dinner in Adrian, Michigan. So if you can please explain to the court what happened on that date and location, please.
Yes, Your Honor. That was the date of my grandmother's funeral, and after the funeral proceedings and the cemetery service were completed, everyone went to the church for a dinner. When I arrived at the church, I was informed by my father, Byron Tolton, that Russell had approached him and asked him to ask me to meet.
That's hearsay. That is hearsay, Ms. Hennigan. What did Russell Hennigan, your father, do to or say to you at that time? What you're telling me, that's hearsay. You're suggesting some third party told you.
Well, I went with that third party to go meet with him because I was asked. And so I went to go meet with Mr. Hennigan to see what he wanted to tell me. I had no idea why he wanted to meet with me that day. We went into the foyer of the church, and I waited for Mr. Hennigan to finish speaking with some guests who were leaving. I sat down on a couch that was in that foyer and was also kind of in a corner of the foyer. And there were two other individuals present there with us. Another individual sat on the couch with me, and the third individual stood next to Mr. Hennigan. Mr. Hennigan proceeded to tell me that he felt that I had been disrespectful to him for something that I had said to him. I believe it was the day before. I can't say for certain if it was the day before, the day of. Those days kind of all run together for me. At which time I said to him, I'm not going to sit here while you complain to me. I thought that what he was complaining about was ridiculous, to be honest, but I just said, I'm not going to sit here and do this with you here. And I got up to try to leave. Mr. Hennigan refused to let me leave. He spread his arms out in a manner that I can best describe as someone who's playing basketball, who's trying to defend a shot. He put both arms out side by side. One was touching a wall. As I indicated, I was in a corner. I was stuck in that corner. He threatened to beat my ass. I told him he was not going to do any such thing and to move out of my way and let me leave. He refused to let me leave. He continued to yell and scream at me and threaten me. Then a third person placed their body between us to make an escape route for me. I left and went around the other two people that were in the room, proceeded back into the dining hall. When I got around him, Mr. Hennigan then came after me, continued yelling and screaming at me in the dining hall. And I told him to leave me alone. You're not even my dad. Leave me alone. You don't have any authority over me. At which time he screamed that he's the motherfucker that's going to beat my ass right now. And he continued to yell and scream until he was asked by other people in the church to leave the church. And I exited out the door that we had previously been outside of and went out to the front of the church.
Okay, and the two individuals that witnessed this, that they're present today, is that correct, in the waiting room?
Yes, they are, Your Honor.
And what are their names?
Byron Tolton and Cassandra Tolton.
Tolton? How do you spell that?
T as in Tom, A-U-L-T again, O-N as in Nancy.
Tolton, okay. Byron, and I'm sorry, who's his wife's name is?
It's not his wife, Your Honor. It's my younger sister, and her name is Cassandra.
And you're suggesting to court they would support your testimony?
Absolutely, Your Honor.
Okay. And again, this occurred on February 27th,
Yes, Your Honor.
2024, in Adrian, Michigan. Is that correct?
Yes, Your Honor.
And when you refer to Russ Lungan Jr., you're talking to the respondent, your father in this case. Is that correct?
I'm talking to the respondent.
Okay. And you felt that your personal safety was threatened?
Absolutely.
Okay. Okay. Mr. Hennigan, normally I would you'd give a chance to respond to this time. Do you want to hear first of all the testimony of Byron and Cassandra? Yes, I would. All right. Okay. First of all, this is your opportunity to ask Tamaris any questions. If you have any questions for her, now is your opportunity.
So you say that you did not know the reason why you were called into the other foyer, correct?
I'm sorry.
What's the relevance? Does it matter? What's the relevance? He want to know, don't you know why you were called into that area? And I'm just suggesting it's not relevant. It's not relevant why she was. It's a question of whether or not she was prevented from leaving this area and whether she was threatened. That's the only issue before this court. So go ahead if you have other questions for her, but whether or not, if she knew the reason for it, I guess it's really not relevant. There may be a good reason, but it's not relevant to the hearing today. It's correct. If in fact she threatened you, you can get a PPO if you feel threatened. But she has testified that you prevent her from leaving an area, you put your arms up, you pursued her, you threatened to beat her ass. That's what's critical this afternoon. So do you have any other questions regarding her testimony?
If I can't question the testimony itself, it's not correct, but I can't question.
Go ahead. No, you can question her.
Your Honor,
can
he get closer to the mic? I can't hear what he's saying, Your Honor.
Okay. Okay, he's right next to the microphone. Go ahead, Mr.
Speak up here. Is that better?
Yes, thank you.
Thank you. Yeah, I was just asking if it was in regards to the situation started because she told me that.
You got to put in frame of
She-
question.
Did you or did you not tell me the statements that you made were a joke?
Are you referencing the statements I had made the day before?
Yes.
Yes, I did.
Okay. Did you or didn't, when you told me that they were a joke, did I or did I not say to you, Tamaris, we do not see to eye. We probably never will see eye to eye. But the disrespect.
Sorry, what's the question? I mean,
I'm asking, did I ask her that?
okay.
Did I say those words to you, to her? But the disrespect has got to stop. Did I or did I not make that statement to you?
You absolutely did.
After I made that statement to you, you made the statement that it was a joke. Am I correct?
I already testified to that.
Okay. After you made that statement, and I then said to you, did I or did I not say to you that all I'm asking you is for us to get along? And you
No, you
then,
didn't.
okay, you then made the statement that you do not have to respect me and that I am nothing to you and that I am dead to you. Did you or did you not make that statement?
That's a paraphrase of some of the things that I said, but that's not how I said it. And no. I'd be happy to testify more accurately to what I did say, but no, I didn't say that.
Under the understanding, and I heard you tell me that you did not have to answer any questions I had, you did not have to respect me, and that I was dead to you as far as you were concerned. And you then got up and began to walk away as you were saying that. And as you walked away and said, you're dead to me and I don't have to respect nothing that you say to me, is when I said to you, well, if that's the case, I can knock you out. And I'll admit that I said that, sir. I'll admit that. But she is the one that, I mean, this is going on for years. The disrespect, I mean, she just says anything that she wants to me. And I mean, I'm at a point to where this is gone far enough to where it's no longer like I can't say that because you said that's hearsay, but I did not block her in any way. Because like I said, I'm a man, I will stand there and said, after she told me that I was sensitive, I'm going to admit that to the court. I was sensitive because we just buried my mother. That I did not speak with Your Honor for 6 years to stand up for her, to my mother, for 6 years. I seen my mom once in 2019, and the second time I seen her was in February 26th in a casket at the funeral. Because the defendant, she told me that you never stand up for me. These were conversations that we had. You never stand up for me. You've never done anything for me. And when she got into the incident, she was in the hallway crying, and I went to my mom and said, Mom, this is enough. And Your Honor, I stood up to her, to my mom for 6 years. And when she said to me, you're dead. Now I just finished burying my mom. And I mean, and now you're going to turn on me and all the things that I've done to try to help you. I mean, I couldn't even believe it. I really couldn't. I mean, and I literally, I'm going to hope that he's going to testify and say, because I turned and at Mr. Tolton and told him, this is why I cannot communicate with her, because she blew up As soon as I said anything to her, she blew up. And I turned to Mr. Tolton to my left and said, this is why I cannot speak with her, because she will not talk, sit down and talk. He always wants to blow it up into a situation. So, and when she blew the situation up and then said to me, I do not have to respect you, and I do not, you are dead to me. Yes, Your Honor, and like I said, I did say, how about I just not get it? And like I said, I'm an honest man, I'm not gonna lie. But like I said, she's the one that provoked the whole thing. And I mean, I hadn't even seen her, Your Honor, in 2 years. You know, the thing where she says that she was threatened and all that stuff, I hadn't even seen her in 2 years.
That's the court will take that. You've not seen her in 6 years. Mr. Hennigan, you do acknowledge, though, that you told your daughter, I'm going to quote, knock you up.
Yes, sir, I did.
Okay. Yeah, did you prevent her from leaving that corner of the room?
No,
Put your arms out.
No, sir, I did.
After she left, did you pursue her?
No, she was right there. And when she walked away, she walking away, she said to me, I do not have to honor you. I do not have to respect you. I did not pursue her. I stood right there in the vestibule where we were at. And I said, how about I just knock you out there? And then she went into the other room, and then they left. And then I went through the same room and went down this way to where my wife and my other daughter was staying.
But you admit that was a threatening statement that I'm going to knock you up?
Yes, sir, I would admit that.
Okay.
Yes,
And I understand you're responding to a situation where you felt that you were being disrespected as her father. But obviously, you've got to be careful with your choice of words.
yes, sir. I like I said, I'm a man. I'm going to tell you the truth. I'm not going, and like I said, I tried to do the best I can. Like I said, everything that was submitted, like I said, and it's all, it's all been here or there, but.
Right. Right. Thank you. Ms. Tamaris, Hennigan, was your father close enough to you to strike out to you and slap you or punch you if he wanted to at that time?
Your Honor, we were nose to nose, and he was screaming in my face and holding me, not physically holding me, but blocking me into.
Did he ever touch you? Did he ever touch you?
Not with his hands. When I tried to leave, I tried to get him to move his arm, and I would press my body up against the arm to try to go around, and I could not. But Your Honor, I'm really asking if you allow me to call my witnesses. He's not being honest with you at all. I did not ask to speak with him that day. I did not provoke this situation. And not only that, but I didn't even say the things that he is saying that I said in the way that he's relaying it to you. And this is why, part of why I'm afraid of him is because I can tell from conversations with him and from the response that he gave to this court that he is no longer in touch with time and details. He's called his wife his fiance at a time when he had been married to her for 2 years. He's told you in his response that he hadn't seen me for 4 years, and today he's saying 2 years. He's telling you he didn't see his mother for 6 years, and then he says he saw her in 2019. That's not even 6 years ago. And I'm not saying any of that to come against him. I'm telling you, part of my fear comes with his lack of touch with reality at this point. I could have never imagined in my life that I would reach a place where I would be afraid that the person who helped to conceive me might shoot me or harm me. And he can paint the picture that he wants, that he's always been a helpful father. None of that is true. And I don't have time to debate it. There's a reason I'm adopted at this point. But what I did say to him that day is he said to me, you don't even respect me. And I said, no, I do not. You told me that my conception ruined your life. Therefore, I allowed myself to be adopted so that I could fix that issue for you. Now, please leave me alone.
Right.
And
There's clearly hurt feelings on both sides.
And there are
But
other
let me ask you, today, are you fearful of your personal safety and well-being hold on, let me finish the question yet. Are you fearful of your personal safety and well-being with respect to your dad? Do you think your dad's going to come after you?
I think that Mr. Hennigan would harm me. I think that he would harm my minor child, and I think that he would harm my dog, which is why I included all of that.
This has
Yes.
nothing to do with your child or your dog. I'm talking about, do you feel your father would harm you?
Yes, Your Honor, 100%.
All right. All right. And what will these witnesses testify to?
Mr. Talton will testify to the fact that Mr. Hennigan approached him and asked to speak with me. He will testify to the fact that I tried to leave. He will testify to the fact that a third person had to help separate us. He will testify that he saw him follow me when I did leave.
The court will allow him to testify, but he's got to testify as what he saw, not what that
He will testify to all
your
of
dad
that.
want to talk to you. So we'll let in, and we will allow testimony from Byron. Thank you. And Mr. Tolton, are you familiar with both the petitioner, Tamaris Hennigan, as well as respondent Russell Hennigan Jr.?
Yes, I am.
And how do you know them?
I met Tamaris' mom when she was 4 and married her. And I've been in her life since.
Okay, I'm sorry. So I'm sorry. You're married right now to Miss Hennigan?
No, I'm not.
Oh, I'm sorry.
We were married for 7 years.
Former spouse. Gotcha. I'm sorry.
Right.
Okay. Mr. Tolton, were you present at a funeral luncheon in Adrian, Michigan on February 27th of 2024?
Yes, I was.
Where both of these parties were present?
Yes.
Did you witness any incident?
Yes, I did.
Between the two of them?
Yes, I did.
Can you describe to the court in your own words what you saw and heard?
Okay. Russ had asked me to be there so we could talk to Tamaris, and that way I could mediate and make sure nothing went on, who was acting up or whatever. So as they were talking, he accused her of disrespecting him, and she's like, "Well, if that's what you called me in here for, I don't even want to be bothered." So he's carrying on and talking to her. When she gets up to try to leave the little area, he stands in front of her, puts both arms out, like, you're not going to leave. And he got loud and said, "You're not going to disrespect me. I'll beat you down if that's what it takes. I'll beat your ass." And this is right there in the church. And we weren't in front of everybody at that time. It was me, my daughter Cassandra, Russ, and Tamaris. And I thought for sure it was going to go, worse than that. But I guess he respected me enough that I just stood pretty much between them and got her a chance to walk away from the situation. But we walked back in the area where everybody else was still finished eating, and other people heard him getting loud, talking about he's going to beat her ass. And they thought that me and him were arguing. And I just stepped in front of him and said, "Look, dude, you're better than this. We don't need to even go through this." So they thought me and him were arguing. All I did was talk to him, try to calm him down.
All right. Thank you, sir.
You're welcome.
Mr. Russell, do you have any question of this witness?
Yes, sir. Once again, when I spoke with you at the funeral home, am I correct?
Yes.
When we sat in the foyer, did I or did I not say to you, after she said the offense that she did was a joke, did I or did I not turn to you and say, "This is why I cannot speak with her"?
Yes, you did.
Okay.
Yes, you did.
And after I said that to you, then did she or did she not explode because she did not have her exact words, and you said that I don't have time for this. This is not, I don't even see, this is not anything. Why do I have to sit here? If this is all you want, why do I have to sit here and listen to this? Is that not what she said?
Yes, it is.
When she then stood up, I asked her, and I said, "Well, I'm trying to let you know that it was disrespectful, the things that you said." Did I or did I not say that to her?
Yes, you did.
Did she not then speak to me in the tone and say to me, I do not have to respect you. I do not have to do anything that you're asking me, and you are dead to me. Did she or did she not say that?
Yes, she did.
And that was all said prior to me making any moves to her, prior to me saying anything about knocking her out, any of that. Wasn't that what actually happened? And once she said to me, I do not have to respect you, you are nothing to me, and you are dead to me. Those words were not the words that she spoke prior to any yelling, prior to anything.
Right.
And once she responded and said to me, you are dead and I do not have to respect you, then I did say, and I told the judge, I did say, then how about I knock you out? And like I said, I'm not going to lie. But the things that I just asked you, if she said, she just testified that she didn't know any of that, she didn't say any of that. And I said that to the judge, that she said that, and she just testified that she did not say none of that. Now, and did I, like I said, I did turn to you and ask you, and I pleaded with you, actually. I turned to you with a plea. Byron, this is why I cannot talk to her. Did I or did I not?
Yes, you did.
There was a pleading motion for you to step in just to say to her, at least hear him out. Was it not? It wasn't like I was commanding you or being violent with you. The conversation was totally nothing but a simple, very simple conversation. Am I or am I not correct?
At that point, it was.
And it did not escalate into anything until her words to me were, I do not have to respect you, I do not have to honor you, and you are dead to me. Is that or not correct in what was said before anything, any knocking on anything of those natures? Was that what was said? Is that what she said to me?
I'm pretty sure that's what she said.
All right, thank you, Mr. Tolton. I don't know if you have any questions, Ms. Hennigan and Mr. Tolton. I think it's the point's been made. Do you have any witness? Do you have any questions of this witness?
Yes, Mr. Tolton, how many times did you hear Mr. Hennigan threaten me?
I don't know if it's 3 or 4 times right then. That particular time.
Do you believe that anything that you saw me do was cause for him to threaten me?
No.
Did I try to leave?
Yes, you did.
And you already testified that he blocked me.
Right. I don't believe if I'd stepped in, you'd been able to walk away.
Thank you.
He was upset.
And you testified that when I went into the next room, he followed me.
That's correct.
You saw him follow me?
Yes, I was still walking with him, trying to get him to stop.
And did you see and hear him threaten me again in the next room?
Yes. That's when the other people also heard him say, I'll beat your ass. And I don't remember what else he said, but I just thought that was pretty crazy at his mom's funeral.
And regardless of whatever everyone's perception is of the words that were said that day from me, do you feel I was explosive towards him?
No, I don't.
Thank you. That's all, Your Honor.
Right. Thank you, Mr. Tolton. You're excused.
All right. Thank you.
You're welcome. You can hang up.
All right.
Miss Hennigan, presumably Cassandra would testify to the same thing, correct?
Yes, Your Honor, she probably would. And the only other witness that would tell you anything separate about this incident on this day would be Dewan Hennigan, who's also in the waiting room, who would testify that he was in the next room and heard the threat and saw Mr. Hennigan following me in that room. And then he left his position to come and check on me to make sure that I was safe because he heard the threat and came forward.
All right, the court does not believe we need cumulative testimony this afternoon. I think the court has heard enough. Mr. Hennigan, do you have any witnesses you want to call?
And there was no one other than those
Okay.
people.
All right. And it sounds like you're all going to testify the same thing. Based upon the testimony that the court has heard today, let's assume for a benefit of the argument that your daughter was being disrespectful to her father. And, but that does not give you the right to block her passage from a room. She testified to that. Mr. Colton verified that. And you've acknowledged that you made a threatening comment that you were going to beat her down or knock her up or whatever along those lines. And that testimony has been supported by not only Tamaris, but also by Mr. Tolton. Ms. Hennigan has testified that she remains today generally fearful for her personal safety and well-being. So I understand there's a lot of emotions at that time. Obviously, the court is not making any judgment on your raising of your daughter and being a good father. You seem like a very relaxed, gentle person today. There was a lot of emotions that night. But notwithstanding that, you don't have the right to block her passage or to make comments of that nature. So there's any comments. So at this point in time, based upon the testimony presented, the court's going to deny your motion to terminate this. This PPO will terminate automatically within 1 year. The day it was entered. I understand you have a concealed weapon permit. You want to carry that, but that's state law. This court did not deny your right to carry a firearm.
No.
That's something with state police and state law. I understand that's your concern. You want to be able to carry that. But that's what state law wasn't an order of this court. But at this point in time, the court's going to deny your motion to terminate this PPO based upon the testimony that's been presented. I regret that it had to get down to this. So the court will enter an order. You'll both be mailed a copy of this order denying the motion to terminate. And the court will just pray that the two of you can find some peace together. Life is too short. So I'd pray that the two of you can repair that relationship at some point in time. All right, that will conclude this hearing. Everyone can zoom out, and good luck to both of you.
Thank you, Your Honor.
Sir.